Hello friends, in the series on the income tax cases, today we will discuss the case of VIP Housing and Properties versus Income Tax Appellate Tribunal and others. This case has been reported in 452 ITR at page number 306. The matter has been decided by Madras High Court and the date of the judgment is 31st March 2022. This matter relates to the assessment year 16-17. In this case, one peculiar situation is there that in this case, the appellant is Assessee and the respondent is Income Tax Appellate Tribunal. Generally, it doesn't happen that the respondent is Income Tax Tribunal. The facts of the case are a little bit unique. In this case, the assessment of the assessee was completed under section 143 subsection 3. After completion of the assessment, the learned Principal Commissioner of Income Tax initiated proceedings under section 263 and did the order for doing revision under section 263. The assessee moved to the ITAT against this order for doing the revision under section 263. While this matter was pending before the ITAT, the assessing authority issued notice to the assessee to file the submissions, documents and the evidences for completing the assessment under section 143 read with section 263. It was the submission of the assessee that my matter is pending before the ITAT for the same matter. So these proceedings should not continue till the order is passed by the ITAT. But the assessing authority was not interested in this submission. So the assessee has to move to the High Court by filing the writ petition. When this writ petition was listed for hearing, the court said that the assessing authority can go ahead with the assessment under section 143 read with section 263, but if the order is against the assessee, then until and unless the order comes from the ITAT, the demand notice under section 156 should not be issued. Meaning thereby that the crux was that it was the viewpoint of the court that there is no bar against the assessing authority to continue the proceedings under section 263 read with section 143 subsection 3 even if the appeal of the assessee is pending with the ITAT against the order under section 263. The only relief which the assessee got by moving to the Madras High Court by filing the writ is that the court said that the department should not issue the demand notice until and unless the matter is being finalized by the ITAT. Friends, see the situation of the litigation in these type of cases. Nowadays, if we read the ITR tribunal or the various cases, we came to know that a number of the cases are coming on the revision. That is section 263. The soul of 263 is that if the order of the assessing officer is erroneous and prejudicial to the interest to the revenue, then the Principal Commissioner of Income Tax has the power to do the revision. If the focal point of the revision is that the order is erroneous of the assessing officer, then my humble submission is that when the order is erroneous, it means that the assessing officer has not applied his mind. So when the department chooses the matter for 263, then at least in those cases there should be some action against the assessing authority who has taken the decision and passed the assessment order. At least there should be some strictures passed against the assessing authority that you have passed these orders without the application of the mind. Why only the assessee bears the heat of that thing that you pass any order, you are not doing the verification for passing the order. And when the Principal Commissioner of Income Tax comes to know of these things, they can simply revise the order without having any action on their officers. This is the pain area of discussing this case. the assessee is suffering. Nowadays, a lot of 263 orders are being done. The level of section 148 assessment has been done in such a reckless manner that the criteria for issuing the notice for the normal scrutiny is a little bit tough. But you can issue the notice under section 148 in any manner. And even if we are moving to the court, then the courts are saying that you have to go with the assessment. How recklessly the department is issuing the notices in these cases is really very alarming, and there is a very pathetic situation for the assessee to go ahead with section 148 assessments. At the end of this video, once again I am repeating the name of the case. The name of the case is VIP Housing and Properties versus Income Tax Appellate Tribunal and others. And this case has been reported in 452 ITR at page number 306. The matter has been decided by Madras High Court and the date of the judgment is 31st March 2022. Thank you, friends.